Then, paragraph 89, as if the tax on and disdain for Heritage Western Cape to that point are not enough, they dedicate an entire Section 8 to challenging the rationality of Heritage Western Cape's requirements. This attack is based, in the first part, on the uncontroversial and logical statement by Heritage Western Cape that if the grading of the significance is wrong, then the conclusions will certainly be wrong. Surprisingly, what follows does not dispute that the consultants got the grading or significance wrong. That on its own, we say, is fatal for its validity. Instead, they build an argument around the assertion, again laced with problematic innuendo, that, and I quote, the real world of complexities in play here cannot be understood through linear equations of this sort. On page 253, the complaint in relation to post-rationalizing a preconceived development is eventually addressed directly. Instead of acknowledgement and correction by the consultants, they have a combative rebuttal, simply asserting that the claim is fallacious. We know from the evidence that it isn't. The main thrust of the rebuttal is that a development proposal must precede a study of its impacts, and that the Act intends that the compilation of an HIA is to have an internal effect on the design of the proposed development. With respect, the Act says no such thing. That a development proposal may change during the course of an assessment goes without saying, but once a final proposal is settled upon, the job of the consultant is fairly, objectively, and independently to assess the significance of every one of the heritage resources and to assess the impact of the development on those resources, along with compliance with all of the requirements of the Heritage Authority in Section 38.3 and 8 of that. It is not the role of the consultant to go out and bat for the development. Notwithstanding the claims in the conclusion to the supplement, the end result of the supplement is that before we even get onto the First Nations or OFMAS report, there is a failure to comply with any of paragraphs A to D, F and G of Section 38.3. That translates into a failure to comply with the first part of the proviso to 38.8 because the evaluation did not fulfill the requirements of the relevant Heritage Resources Authority. We then go on from page 39 to deal with the First Nations report. And there are two components to it. The one is the question of whether or not there was meaningful consultation, and the other is whether or not it constituted the correct response to the requirement that a specialist consultant be appointed to file a supplementary report. In relation to meaningful consultation, we say that if we look at 38.3, if we look at what Heritage Western Cape said, and again, it's perfectly clear what they said, they want meaningful consultation with First Nations groups. We say that as far as it was reasonably possible, all First Nations groups had to be consulted with, that the consultation had to be meaningful and genuine, and that the diverse views of all such groupings had to be heard in the process. We then refer to the extract from the Scalabrini judgment, which says what consultation should be like. Coming out of that are required a genuine invitation to give advice, genuine receipt of that advice, not to be treated perfunctorily or as a mere formality. Engagement after the decision maker has already reached his decision or once his mind has already become up would not be compatible. The procedure must be one which enables consultation in a substantive sense to occur. This means that sufficient information must be supplied to the consulted party to enable it to tender helpful advice, and sufficient time must be given to the process. We then, at paragraphs 99 and following, work through the flaws, some of which I have discussed with your ladyship. So I've already dealt with the precondition that was imposed. That's dealt with in paragraphs 99 through to 101. And we give the reference to the New Nation judgment, which talks about freedom of association in footnote 3. In paragraph 102, we say, as the report develops, any pretense of objectivity, independence, and inclusiveness is discarded. Instead, he goes on the offensive against the Gorinhaicona. And I've read to your ladyship what he put out so offensively in the report. We say in paragraph 103, the denigration of the Gorinhaicona, the second applicant in these proceedings, through Mr. Orance's adoption of this archival material, amounts to gross racism and is the clearest evidence that the report can in no way be relied upon and could never on the decided authorities amount to statutorily and constitutionally compliant consultation.
Well, I would imagine that they have the freedom not to associate, but by refusing to participate, who must bear the brunt of that? If you get an invitation to participate, is the applicant saying that the invitation was just superficial and it did not serve any, it did not fulfill the requirements of meaningful, let me just see the quote that you've given here of the Rogers judgment, a genuine invitation and a genuine receipt of that advice. How can you assess the genuineness of an invitation or the genuineness of the advice that you give unless you participate first?
Well, the difficulty is what we set out at paragraph 99. It wasn't just an invitation to come and talk, to come and be part of a consultation process. It said, you have to join Western Cape First Nations Collective. If you don't join, you're out. You're in exile. We're not going to talk to you. That's not a consultation process with respect
So
to
can
money.
you just refer to the papers? Where will I find that?
That
Evidence
relationship,
of
it's,
that
I've got it set out at page 40 of the notes in paragraph 99.
Oh, 99, yeah.
I left it out because I'd referred to it
Yeah.
in
Well, the fact
exchange.
that someone says, you read this already?
Yes.
That the majority, the First Nations Collective comprises the majority. Let me just see. I don't see anything, any exclusion in this quote. How is the one group excluded?
Any exclusion?
Yes, how, where does it say that you must belong to us, otherwise your voice will not be heard? They expressing a view
that's what it
here that
says.
if you're not going to join us, we share the same interests. If you're not going to join us and air your views, it will tantamount to a self-imposed exile. Where does it say you won't be able to have a voice? Did anything prevent the Gorinhaicona to make written submissions or to call for a separate meeting? Were they excluded from doing that?
Well, this was a process being run by Mr. Arendse. He hands over to Chief Zenzile Khoisan.
But it is a chief, it is someone with considerable standing and respect within the collective.
Indeed, Nadi, but it's meant to be a consultation process conducted by Mr. Arendse. He hands over to the chief, and the chief says that he invites the Gorinhaicona to participate and join the collective.
But that is an invitation to join, which any party, I would imagine, can decline, but that would not bar you from expressing your views, albeit in writing, albeit by referring the collective to another party and say, look, we are withdrawing from this process, but this is our representative. You can have your meeting, your engagement, but these are our submissions, or consult our representative. But completely removing yourself from the process, is that not really a recipe for disaster? Can you come back afterwards and say, I was excluded? Is that what the Gorinhaicona was saying, that they were excluded from the consultation process, notwithstanding the invitation from a respectful standing member of the collective?
But they weren't responsible, the collective weren't responsible for conducting the consultation process. And there's a clear insistence that it has to commence with joining this particular group.
Where does it say it's compulsory to join the group?
The position taken by the collective,
cautioning the Gorinhaicona that refusing to formally engage would constitute a voluntary extrication from the consultation process akin to a self-imposed exile. Look, let's be logical. Let's think logical. It's a collective. It's a representation of different interested parties. You have the Gorinhaicona who refuse to participate. You have the chief saying, and you're quoting here what the chief explained. The chief told the Gorinhaicona, if you are not going to participate, let me just look for the word, formally engage, it will amount to exile. In other words, I cannot read into this statement that the Gorinhaicona were entirely refused participation. The chief cannot, it's not the party that's going to determine who must participate and who must not participate. This is just a recommendation or advice or a caution where the chief says, look, this could be the consequences if you're not going to join us. It's more an appeal to join us and a statement reflecting what could result in that. But did that stop the Gorinhaicona from making their submissions? Did anyone send them an email or note saying, we don't want to hear your views? Had they compiled their own document with their views and sent it to all interested parties or the respondents or whoever, do you think it would have been ignored? Then there would have been a basis to say that they were entirely excluded. Can self-exclusion amount to total exclusion?
But with respect, it's not self-exclusion. When you're presented with that threat, and when it comes on that basis, that's not inclusive.
I'm sorry, I'm not in agreement with you. It is not a threat. I don't see a statement here. And you know, it's wordplay. One must be careful how you want to interpret the word, underlying wordplay here. There's nothing in the words of the chief that says, if you are not going to join the collective, you will not be allowed to state your case. The caution here is, be part of the group. We share the same interests. Let's work together as a collective, and we all know there's strength in numbers. It's better to consult a collective than individual parties. They must, because there are risks involved in one group standing on their own, because then they're not joining forces that could strengthen their case. But by the same token, no one was excluded as an individual.
But
I don't read in this cautionary words of the chief. I cannot read in here that the Gorinhaicona were told or it was demanded from them, either or. Either you join us or your views will not be heard. I don't see it here.
Well, I can take it no further, lady. That's the submission I make. Is the most reasonable interpretation of that. What bears it out, lady, is then how the report develops.
I don't see a precondition here that they join. I see it as an invitation to join.
So, but lady, perhaps if I can just ask you to consider.
Let us pause here for a moment. Let's reason logically here. Did the Gorinhaicona make any attempt to submit their views with regard to this development outside of the collective?
I don't know what's happening in the record outside of this, but this is the statutory process that's been decided on. It must happen through Mr. Arendse, and this is how Mr. Arendse is conducting it. And the review of the process must stand or fall by what took place.
Are you saying that Mr. Arendse's involvement was irregular by calling together this particular group as someone who has some experience or expertise with relation to the groups that were being consulted? Was Mr. Arendse's involvement in any way detrimental to the First Nations?
Well, yes, it was detrimental as we see as it develops, because what we then see is what the underlying approach and attitude was. So, for example, he then goes on to gratuitously cite the archival references that I'm talking about. This is a person who's meant to be independently, fairly, and objectively consulting with them, takes a very firm, biased view against them as a grouping, and then says at...
Do we have the reasons why the Gorinhaicona did not want to be part of the First Nations collective?
It's dealt with...
From the start, what were the reasons that they did not even want to attempt to be part of this group, that they distanced themselves from this group? What was the reason? Because remember, you cannot remove yourself from a process and And I will use the word cautiously, with the word sabotaging a process. I will use it cautiously. But you cannot remove yourself from a process in an attempt to possibly sabotage the consultation process and use that as a reason later on why you contend that consultation was not meaningful, it was not bona fide, and the invitation was not genuine. I'm just quoting the case here, and that the receipt of the advice was from the word go, not genuine. Do you understand the concern that the court is raising? Remove yourself from a process and raise that as a reason why you say the process is not legitimate. That is the concern that the court has.
I understand the court's concerns, and I need to refresh my memory as to what Mr. Jenkins says is an affidavit. It doesn't immediately come to mind.
Because it's not easy to extricate yourself from a process and expect the court not to raise it, because this court must look at the positives and the negatives,
of course, Milady,
in respect of all the cases, and try and create to find the balance between the respective rights. I mean, we must still deal with for example, with balance of convenience. We will still probably get there later this afternoon. But as far as I'm concerned, we're still dealing with a question of apprehension of harm at this stage, because it all points to one aspect. There was not proper consultation. Consequently, there is this possibility that a part of the one group comprising part of the First Nations could suffer irreparable harm should this project continue. So the court must ask the difficult questions as well.
No,
why remove yourself from a process? Can you claim afterwards, but there was not proper consultation?
Indeed,
and use that as a reason to say 38.8 was not complied with because of that flaw in the consultation process.
Lady, the person who conducts the consultation process has to be a person who is trusted and builds trust in the process. And Mr. Arendse did the exact opposite.
Mr. Arendse what?
Did the exact opposite. He didn't build trust in the process. And if there were concerns about the process, he effectively confirms in his own report that they were justified. He had a prejudice.
How did he not facilitate trust in the process? If the chief makes statements, you cannot attribute those words to Mr. Arendse, because he's not entitled and he doesn't have the gravitas, the necessary gravitas, to make the statement that emanated from the chief. We cannot apportion any blame to Mr. Arendse for a statement made by a person with that gravitas and who commands that amount of respect in the First Nations collective. He had the authority to say what he said there. It's not Mr. Arendse's territory to communicate that to another group, part of the First Nations. I'm not saying collective, of the First Nations, because all of them have equal standing as far as this court is concerned. They share common values, common heritage, common history, common culture, and they have a common interest, which is the protection of this specific areas, which constitutes both tangible and intangible, a tangible and intangible heritage resource, which the court appreciates and wanted to clarify quite early during the proceedings, that it's going to be very difficult for any party to stand up today and say, or in the next few days to say, there are no remnants of intangible heritage, because we all know intangible heritage is an abstract term, and what it means for one group can mean something else for another group. And I actually did some research into the term, and I noted some academics actually stated that there were so many definitions for intangible heritage, because it can constitute so many things when one look at the world, Africa on its own, South America on its own, when you look at the traditions, rituals, folklore, whatever you do. It was difficult to actually define it. There were so many definitions for the word intangible heritage. So it's very difficult for any party to get up and say, there are no remnants of intangible heritage. So on that score, the court is with the applicant, that the territory constitutes both tangible and intangible heritage resources.
As the court
So
pleases.
I'm back to my point. We're not attributing those words, and we cannot attribute it to Mr. Arendse. He does not have the authority to convey that message to the Gorinhaicona. Doesn't have the standing, doesn't have the authority to do that.
That he
It would actually be would have been quite bad for Mr. Arendse to have said that to the Gorinhaicona, and actually quite disrespectful, because he was just there as a facilitator. Or am I wrong if I say that? He was there as a facilitator
No,
for
he
the,
wasn't
for
there
the
as a
first,
fac- wasn't there as a
for the
facilitator.
First Nations Collective, to allow them an opportunity to ventilate all the issues, to consult with them regarding issues that impact them in terms of their cultural
No,
and
no.
historic.
With respect, no, my lady, he was there to conduct,
Significance.
he was there to oversee a consultation process.
Exactly.
He
The
wasn't,
court noted that.
he wasn't there to facilitate a discussion between other people. He was there to oversee a consultation process, and he was the consultor. All of the other people were the consultees. But I've taken that
Are you
submission as...
saying that the collective could not consult each other? Because that is actually where we need to pause. Ultimately, when one analyzes the caution given by the chief, he was saying, be part of us, because we are going to try and come together as a group and find the best way forward for the First Nations. Do what is best for the First Nations. And try and find common ground in terms of the way forward.
Lady, I-
So, sorry, I need to pause because I'm a bit concerned if you say that Mr. Arendse's role had negative implications. Is that what you are saying?
that Mr. Arendse,
His role must be viewed negatively and not positively.
well, on his own report, we say so, my lady. On his own report, and the report goes on to get worse in the respects that we described in the heads of argument, where he eventually starts making very, very prejudicial statements about the second applicant. Openly racist statements that our constitution would not accept. Now, how can one have somebody who's willing to put that down on paper, conducting and convening a consultation
So, which
process?
statements are you referring to?
The ones that I read earlier during the proceedings, my lady.
You're talking about the Van Riebeeck statements. Which statements are you referring to?
The one from Jan van
statement?
Riebeeck's, the
Yes.
ones from Jan van Riebeeck's diary. And he goes on to say,
Quoting from someone's diary, that statement is also not attributed to Mr. Arendse, but I understand you're saying he should not even have quoted it in the first place because it was aimed at delegitimizing the second respondent. Is that what you're saying?
I'm saying he adopts it as part of the reasoning in his report. And
But
then,
ultimately, Mr. Arendse will not have the final say in the consultation process. Am I correct if I say that?
ultimately, Mr. Arendse will not have to.
He will not have the final say as to what is discussed by the First Nations Collective and what is agreed to by the First Nations Collective. Mr.
No,
Arendse
the-
will have
the
no say
consultor-
in what happens and what
Indeed, Melanie.
they present to him.
Indeed, my lady, the consultor can't tell the consultee what they're going to say. But he needs to go about it in a way that doesn't reflect a prejudice towards one of the parties. And what I'm saying is that his report reflects open prejudice. He goes on to say, in response to a point where he discusses Jenkins' concern that this is a battle of restorative justice. This is at page 42, paragraph 104.
Sorry, where are you now?
Page 104, page 42, paragraph 104.
Oh, 42. Where are you in your
At
notes?
the bottom of page 42.
Are you reading from your notes?
Yes,
Oh, 42.
bottom of page 42.
Oh, yeah, I see, yes, 102, you're referring to the diary.
This is what he thinks of a comment from Mr. Jenkins about this being very sacred ground. He says, First Nations Collective made it clear that they and only they own the indigenous narrative. Also, only they have the right to deploy the indigenous
Sorry,
narrative.
which paragraph are you? I'm not with you at the moment.
It's at the bottom of page 42.
Oh, 42 bottom, yes?
Bottom of page 42.
Yes. Oh, are you reading from paragraph 104?
Correct, lady.
Yes, I'm with you.
Correct. Again, that indicates a deeply problematic acceptance that the only people who can really be spoken to about this is the First Nations Collective. And it confirms what I said earlier, that you would have to join the First Nations Collective if you were going to have any say in the matter.
But if the First Nations express this view to Mr. Arend Sawad, should he not express it in his report?
Because
He did not suck that information out of his thumb. He quoted what he was told by First Nations. It's not his statement.
But
If the First Nations Collective made it clear to him that they own the indigenous narrative, which is probably correct, isn't that a correct statement? The First Nations, they do own the indigenous narrative, their own narrative. No one can tell the First Nations how to express and how to and give any views on the significance of their cultural and historic significance. No one else can do it except themselves. They are the owners of the indigenous narrative.
But
They
this
are the owners of their own culture and traditions. No one can prescribe that to them.
but Milady-
Is there anything wrong with that statement?
Lady, this is one small group of them.
The
This is
First
one-
Nations
The
Collective.
First Nations Collective. We know from
Yeah.
the papers that it's not everybody.
Yeah, I would like to hear the respondents on that because I am a bit unsettled when the applicant say this repeatedly, that we are dealing with a small grouping that represents the First Nation Collective. There are many groups that are excluded. Is that what the applicant is saying?
So, Milady, I dealt with this issue earlier. I said what the difference was between the two reports. I said that there's a list that's provided in Mr. Jenkins' affidavit. Perhaps, I'm not sure if your ladyship is intending to take a lunch adjournment, but we can get the references
Yeah,
in the course
perhaps
of
you
the
should
lunch
do
adjournment.
that.
It's difficult for me to do
Yes,
that
but
on
the
my feet.
respondents must most certainly address the court because if a large group is excluded from the collective, it creates a big problem because then there is most certainly a basis for the apprehension of irreparable harm. Most certainly.
We'll provide,
Yes.
we'll provide the
Just
references.
check the
ma'am.
time.